Good morning, everyone. We are about to start our seminar, our East-West Forum, with focus on the Baltic states and Poland. We are waiting a few minutes more and then start our presentations. So let's start our webinar. This webinar is the second of the SCC's events devoted to East-West disputes. And as many of you know, the Stockholm Arbitration Institute is an arbitral institution with strong reputation of a neutral forum, traditionally popular among the parties from Europe, Eastern Europe, and the CIS countries. And in other words, it is very much involved into the East-West dispute resolution. The parties from the Baltics and Poland are among the top 10 most represented nationalities on the SCC's caseload, as you can see here on this slide. The main feature of the disputes coming from the region is their fantastic procedural diversity. We see small and big cases with claims ranging from a few €1,000 to almost $1 billion, with seats of arbitration all around the region in big and small cities such as Stockholm, London, Berlin, Tallinn, Riga, Vilnius, Gdańsk. The SCC rules are flexible and compatible with most of national arbitration laws, which is very important for the arbitrations with seat outside Sweden. And today we will enjoy a discussion with the top lawyers from Poland, Latvia, Lithuania, and Estonia, who will give you an insight into arbitration and dispute resolution in their home jurisdictions. The webinar will consist of 3 parts. We will start with a keynote address by Aku Saarinen, the founding partner of the like-named law firm, who will share with us his unique experience of leadership at one of the biggest law firms in the Baltics. And after that, we will go on with a panel discussion with top lawyers from each of the focus countries, moderated by Fredrik Ringqvist. And finally, we will wrap up with an inspirational talk with Ginta Arel and Eva Kalnina, top international arbitrators originating from Latvia, with a lot of experience of arbitrating disputes with the parties from the focused countries. So we encourage the audience to participate. Please put your questions via chat. And now let's start. And I pass the floor to Aku Saarinen.
Ladies and gentlemen, good morning. And thank you for the opportunity to open this very prestigious SCC East-West Forum focusing on the arbitration in Poland and the Baltic states. I learned recently that one should not trust a person with a great PowerPoint presentation, because usually that person has neither power nor a point. Despite that warning, I have prepared a few slides for you, and I hope that by the end of this presentation, I have not lost too much trust by the end. As we know, last year was very different for us all. And exactly a year ago, we were supposed to celebrate our firm's 25th anniversary and organize a great party. And our firm band was to give a great show. We were planning to invite about 200 people and have a actually very large budget prepared for, already approved. But COVID, however, changed it all. we had to cancel the event, and instead we decided to organize 2 anniversary online events. And eventually these online events had a budget of only 10,000 euros. But we had over 1,000 people from around the world. We got much better visibility, much more goodwill than we would ever have gained with the physical party we were planning to do. So COVID offered us a unique opportunity to start to think how to do things differently. So that was how we opened our online seminars. So you see that all the band rehearsals, at the end of the day, they were not in vain, but it was just a new way how to reach the people. Now, what happened in the autumn of 2020? We started to see, after 6 months of lockdown, we started to see rapid growth in economy and the legal market. People were happy to get back to work, though still remotely, after 6 months of very uncertain period. People continued to appreciate the remote working and the new level of flexibility, what we had all learned. And what was a great surprise to us partners, that the productivity started to grow against all expectations. We learned from the large UK firms that they saw a big decline in productivity when people moved home. And for us, it was vice versa. In the beginning of last year, we had to freeze all salaries. We had to postpone payments of bonuses and dividends because nobody knew what's going to happen. But once the business returned a year ago, then obviously also the pressure on salary increases returned, which was quite normal, as also the business was starting to grow. We were very concerned, however, how the people would feel under these new conditions and after already experienced a half a year of lockdown. So we measured these, we actually used this Swedish consulting company Ennova in making these surveys, that how do people feel. And what was a big surprise to us, actually, that there had been no change since 2019. The satisfaction and motivation remained actually on a high level. Little bit this 70 GEL Baltic is the average what Ennova clients have in the Baltics. We were slightly above, and this Ennova top class, which includes also Nordics and Baltics and other countries where they operate. So we were slightly below that. We saw that this employee net promoter score also stayed on a similar level, more or less, although still quite far behind this Ennova top class. So we saw that there is still quite a way forward. And also we saw little bit different dynamics in different countries. We saw that in Estonia, actually this employee net promoter score was increasing quite much last year. In Latvia and Belarus, where the business actually froze most, there we saw decline, quite significant decline in the beginning of the year. They were able to catch up only later. So they also, this score went down, whereas Lithuania also saw quite good growth already throughout the year. So things looked good last year in the autumn. This is we asked open comments from people how they felt, what the firm was doing good, what the firm could be doing better. And as you see on these words regarding what the firm could be doing better, it much rotated around employees and people, and not so much around the salaries and bonuses, which we were concerned that this is a big concern for people because we had to freeze them. But it was we felt that this is more about employees, people's well-being that was in the focus, and where people expected us to also pay increasingly attention, learning the new way to keep people, to take care of people's well-being. Now, people obviously are very important for all law firms around the world. But if you look at how the Baltic population dynamics is moving, I mean, this is amazing decline of population in the Baltic states. Look at 1990 and what has happened in 3 decades. So we are currently having the combined population in the Baltics almost like after the Second World War. So has been quite dramatic. Now, at the same time as we have seen this declining population overall, the business started to boom significantly. And this is from the merger market first quarter this year. As you see, there are 3 Baltic law firms, Ellex, Cobalt, and us, in the top of the whole CEE market. And considering that the Baltic countries only a small fraction of the whole CEE market. So transactions were booming. People were constantly, increasingly underwater. And what were the drivers of these transactions? So one of the drivers is the Baltic unicorns. It's a very special feature of the Baltic states that we see so many unicorns. The startup industry is really booming in Estonia, in Lithuania, and now increasingly also in Latvia. And we already have, as you see from here, 9 unicorns in the Baltic states, comparing to Finland, which has 7, although the population is more or less the same, and obviously Finnish economy is significantly bigger than the Baltic combined. Look at Germany and France. France about 14, Germany about 16. So there's something very special, and considering the differences of the population of Germany, 14 times bigger than the Baltics combined. So there is something very special what is happening in the startup industry in the Baltic states currently. Now, if we look at the revenues of the law firms, this is the first half a year in 2020 comparing the first half a year this year. We get only Estonian data because this is not published in Latvia and Lithuania. So we see almost all law firms having a double-digit growth in revenue during the first half of this year comparing last year. And it's interesting actually, we have been very concerned about how the big 4 are entering the legal market, PwC, EY, Deloitte, and KPMG. And so far, they have not been acquiring significant market share in the Baltics, but we have to keep our eyes carefully open, like I think most of the countries in the world nowadays. But at the same time, as we see these revenues growing double-digit in the law firms, we see that the number of lawyers actually is not increasing that much. We see the top-tier law firm, top 3 law firms, they are pretty stable, and then in the smaller law firms, we see Wallace has been making a significant growth. They have had, I think, 2 mergers during the past 2 years, so that has helped them to grow significantly. So things are developing and changing also, perhaps in the law firm positionings regarding the years to come. Let's see. But what is happening exactly right now? We are experiencing growth like 2007. I remember this was exactly the same feeling, and everybody was underwater. And then came 2008 and 9. So I hope that we are not going to see similar picture realizing too quickly here. We see continuously lawyers learning to be very productive working remotely, but at the same time we see some people already starting to burn out. So we have to very carefully think, what can we do to protect our people from burning out? There are very good elements of working flexibility in this working remotely and offering people the opportunity to work in a flexible manner. At the same time, we have to carefully figure out that how do we integrate the new people joining us. There are tens of new people in the firm who most of us have never met face to face. So how do we transfer the firm culture to them, the firm values, when they seldom have opportunity to meet others? We have seen that increasing transparency in the firm while working remotely has been very good, and people appreciate it. Transparency on how the firm is doing, how different teams are doing, financially, well-being wise, and everything what is their workload, and that helps us to collaborate increasingly between the teams and also between the offices. We look at our bureaucracy. The larger the firm is growing, then obviously it also includes increasing processes and rules in the firm. So we are more critical on the bureaucracy we are creating to ensure that it's always sensible, it's always justified. And working in this flexible manner, there's obviously more need for even more professional leadership at all levels than before. We have tried this summer offering people half Fridays out of the office. And it was offered only for the summer, but it seems that it was very good impact on the morale of people. That they felt that we are not expecting them to be available at the end of the working days on Fridays in the summer, when they had an opportunity and when the work permitted them to actually leave earlier. Obviously, we also expected our people to be responsible. So if there are deadlines to meet on Friday, those deadlines have to meet before people can take off. We have now started also organize real team and office events. We started with having great office parties in each of our offices 2 weeks ago. Yesterday we had a quite major client event in Tallinn office. We have learned that always when you have these offices, you have to have a very careful examination of the COVID passes. People either have vaccinations or they have then COVID tests done before entering the premises and events, but everybody has got used to it now. So these are real actions that we feel are helping our people from burning out. And the final element, what we have learned is that we have to offer psychological counseling for those who are in need of it. And that has been increasing our expectations, how many people actually have been using that counseling opportunity. Currently, we feel that it is in the interest of the firm and our people to invite them to come back to the offices more often. We have not established clear policies how many days people should be in the office, but we try to make it attractive to come back to the office more often. Now, the final thing, what is increasing in the Baltics currently is the attention to sustainability and diversity. And this is an extract of what is the proportion of female partners in the law firms in the Baltics. So we see that the best ones have over 40% already, and the average is somewhere around 30% or a little bit below. I think internationally this is pretty good. We are not happy where we are today, and we have when I look at the partner candidates at Sorainen, I think currently we have half of them are female and the other half is male. So I think this diversity issue is going to get much better during the years to come. So this is in brief, how is the Baltic legal market looking at today? Thank you from my part. If anyone has any questions, we have 1 or 2 minutes, but otherwise we'll hear what the others have to say.
Thank you very much, Aku. That's very interesting, actually, and very interesting information about the Baltic market of legal services and how it looks like with law firms there. And of course, the time that we all had hopefully behind us, was quite difficult and challenging. And it's really, really good to see how a Baltic law firm copes with this. Unless there are any questions to Aku, we can now go over to our panel discussion, and moderated by Fredrik Ringqvist, a partner of a Swedish law firm Mannheimer Swartling. Fredrik works at the firm's Moscow office and has over 20 years of experience of the regions and special expertise in disputes resolution involving parties from Eastern Europe and Central Asia. Fredrik and dear panelists, the floor is yours.
Thank you very much, Natalia. And thank you also, Aku, for a very interesting presentation. Just a brief comment on that. I think the same tendencies are probably seen in Scandinavia as well, with a very high workload and not necessarily a big increase of staff in law firms. So a tough situation for many lawyers right now. And I think it's good that Sorainen, like many other law firms, consider the health of their employees. It seems like you have a good setup there. But moving on then to our topic or our panel discussion, and in this panel, I'm not going to speak that much, but you're going to get to hear from the actual experts from the region, and that is of course Poland, Estonia, Latvia, and Lithuania, and the speakers are going to dive into various current issues related to arbitration in each jurisdiction, and this is not, of course, a homogeneous region, the Baltics and Poland. Different things are happening in the different countries. So, and there are also some things which are common, but I think the range of topics that will be discussed in this presentation show that there are certainly different movements in the various countries. Our first speaker is Beata Gessel-Kalinowska. And she is, she is a partner a named partner in her firm, and she has been working with arbitration since the 90s, both as an arbitrator, counsel, and as an expert. And in parallel, she also maintains I understand, a quite flourishing practice in M&A. So she has a very envious position working broadly in both areas. And she is, among other things, a member of the ICC and also a adjunct professor in arbitration in Poland. The second speaker representing Estonia is Maria Filak. She is like Aku from Sorainen, and she is duly qualified both in Estonia and in the US. She has an LLM from Georgetown, and she is a member of the New York State Bar, if I understand correctly. She is a senior associate and member of Sorainen's dispute resolution group, and among other things has represented, I understand, one of the first, if not the first, Estonian investor bringing in an exit case. The third speaker in the panel is Daiga Zivtina, and she is from ELIX in Latvia. And Daiga is partner of ELIX and also co-head of the dispute resolution practice, and she specializes in commercial disputes. And she also works with white-collar crime matters. She works a lot as well with dispute avoidance and claims management. And she has a significant experience in various kinds of disputes and asset tracing. And she also sits frequently as arbitrator at the Court of Arbitration at the Latvian Chamber of Commerce. And then the last but not least, our speaker from Lithuania, Ramonas I'm going to try to get your last name right. I always get it wrong. Audzevičius, is that almost right? I'm sorry if I got it wrong.
Audzevičius.
Yeah, I got it wrong. I'm sorry. He's a partner at Mateka and Audzevičius in Lithuania, and he is the head of the dispute resolution group there, and he's a very accomplished and internationally renowned business litigator. Who works with both commercial arbitration and regulatory matters and investment disputes. And he has represented clients under various arbitration rules and in various Lithuanian courts, and also before the Court of Justice of the European Union and European Court of Human Rights, etc. So we do have a very distinguished panel of speakers who I'm sure will be able to get you the latest insights from this geographically, how can I say, interconnected yet diverse region. So Beata, please begin.
Thank you very much. I must say I was listening carefully to this what Aku was speaking, and I think this is I can share what he said about the market growth and the development of the legal profession. I have only one comment, maybe. You see, Aku, what is the gender balance in our panel? This is a bit different than it is in the partners level in your firm. So I think, and this is achievable, I would say. So this is a little bit of a gender comment. Well, let me try to share my screen. I also have a PowerPoint, but only one slide, I say, okay. And how to make it bigger. I don't know exactly. I think, I'm sorry, you have to live with this. So with this, what I have on the screen. Well, what I would like to say, I think that we are living in a very turbulent time. And I think we are all facing this turbulence in our all jurisdictions, our 4 jurisdictions. We were going through pandemic time, and we have the migrant crisis generated on our borders with the Belarus. We have a climate crisis, and we have populism in politics, which especially in Poland generates, I would say, unmet earlier tensions, and we see it in the system of justice. We see it in other areas, and all of this, I would say that it has an impact on this, what is going on with the dispute resolution, whether in arbitration or in litigation. This also, I think, puts a certain light into what is really hot in Poland in terms of arbitration. I will speak today mostly about investment arbitration, which is maybe surprising, but this is something what is very the most hotly debated. These are the headlines from our newspapers. So as you know, most of the stuff is pretty confidential. It's not transparent, but certain informations we can retrieve from our media. There are 3 cases what I have been acquainted recently, what was informed in the public domain. The first one is the case, as you see, 2 cases, they are based on Energy Charter Treaty. And the first case is, we got all the information that was the case which was generated by under the Energy Charter Treaty by the citizens of Austria, Switzerland, and Czech, and also 2 Cypriot companies. That was not very big deal. It was as concerning investment arbitration, that was 400 million zlotys. And it was about alleged jeopardizing the investment of the claimants in the cogeneration based on gas investments in Poland. The information is that Poland has won, what me as a taxpayer is, of course, for me, this is a good information. But I think that this is also important information that this case was handled only by the general attorney, which is Procuratoria, the entity which is designed only to run the proceedings on behalf of the state treasury in arbitration. So there was no law firm involved. So this is a bad information for the law firms. That was done strictly by themselves, by the general attorney office. By the way, this is the general attorney office in Poland. This is one of the biggest law firms, I would say, as compared with other private law firms. So there was one case which was won by Poland. We have, that was maybe not the most marketed case in the newspapers, but the other 2, yes, they are not finished. They are at the starting moment. The next one, as you see here, this is the Prayer Mining Limited. This is the coal mine, which was organized in Poland by the Australian investor. And this case is really big one. This is about 800 million pounds on the table. And this claim is based on the Energy Charter Treaty and the Polish-Australian BIT. It is at the very beginning. The most of the information which is in the public domain comes from the claimant. What is disclosed is the set of arbitrators, which is Bridget Stern, Peter Rees, and Klaus Sachs as a president. What I think is interesting to speak on the margin of this, because this is, as I said, this is the starting point of this. This is the proceedings at the outset. But I think that here it will be important to speak about the very, very fresh decision of the Court of Justice of the European Union as concerning the Energy Charter Treaty. The decision was issued on 2nd of September 2021. So that was just a few days ago. That was the decision which was issued in the case Republic of Moldova versus Comstroy. And here the tribunal confirmed application of the ACMEA resolution also to the Energy Charter Treaty. So it means that in this case, also the again the disputes between investors from EU against the EU states is not the one which is possible. And this maybe is not so much applicable to the case at hand. It means to this Australian case, because Australia, as long as it is for now, is not a party to the European Union. But still, I think that this is quite important information if you are talking about the Energy Charter Treaty situations. And then we have the last case, which I wanted to talk about, which was during last weeks. It was just on the front pages of all the Polish newspapers, as well as outside. This is the case which is called Lex TVN. This is the Polish TV broadcast, which is the part of the group of Discovery. The TV broadcast was seeking license from the Polish government to continue their activity in Poland, and they have filed their application in September last year. So this is more than a year. They were seeking this license until now, and the expiry of the license is something around now. It means in October, I believe. And for the very long time, they haven't received any information, no answer whether they will receive the license or not. Instead of it, there was the new law which was introduced to the parliament. The law basically, it was in the public domain stated that the law was directly against this particular TV broadcast, and the Discovery has made a protest that this law and lack of giving license is directed against the television, this particular television, and they have already sent a notice, an official notice based on the BIT between Poland and the US for non-equitable, non-fair treatment of their investment. Right now, the situation is like in a thriller. It's expanding because the parliament, the lower chamber, has passed the draft law, and the Senate, which is the upper chamber of the Polish parliament, it did not accept it. So the thing is coming back to the first chamber. Well, we don't know what will happen. I think that right now the line of the proceedings is much more liberal towards the TV station. The TVN has achieved anyway the Dutch license, which allows them to continue activity also in Poland based on the EU laws. But this is something what has been very heavily discussed, the content of the BIT treaty between the Poland and US. So from the legal perspective, it gave a lot of bidding for the legal discourse on investment arbitration. So these are the three cases which were very loudly discussed recently in Poland in terms of the investment arbitration. And now I think that there is also one case what I wanted to share with you, which appeared in the area of the commercial arbitration. This is not so hot and not so recent as these three investment arbitration, but I remember that when I was sharing this on LinkedIn, it really raised a lot of interest. So I think that this is quite important for practitioners in commercial arbitration. There was the decision of the appellate court in Warsaw as concerning the validity of the arbitration agreement, and that was a very special issue because it was the claimant was seeking annulment of the arbitration award based on the fact that the arbitration agreement was not effective or not valid, based on the fact that he was not able to supply enough financial sources. He was almost bankrupt, and he could not afford to pay his arbitration fee to the court. So that's why he was deprived of his right to defend his rights. And the appellate court said, and that was it was decided by the first instance court and then by appellate, so they were both unanimous in this case, that the arbitration clause remains effective or operative also in situations where one of the parties is unable to shoulder the cost of arbitration proceedings. And the court said that when a party decides to sign for the arbitration, it signs for good and bad. And what was, I think, very interesting, it was said that for good, for example, is that when you choose arbitration, you can have shorter paths to get to the decision. So to some extent, the court said the arbitration is in this respect more effective than litigation. But on the other hand, when you sign for arbitration, you also sign for this worse things. For example, you cannot use the possibility of being released from the obligation to pay the court fees, or in this case, arbitration fees. So lack of funds does not constitute a reason to invalidate the arbitration agreement. And I think this is quite important decision, not only for Poland. Well, summing up, I would say that just also recently in the Kluwer arbitration block, there was disclosed the numbers for Polish arbitration decisions, and it was prepared by Maciej Durbas, Angelika Ziarko, i Tadeusz Zbiegiem. And they have made analysis of the post-award cases concluded in 2020 in Poland. They came to the conclusion, which I support, that arbitration climate is still very good in Poland in terms of the state courts. And maybe I will give you just such a statistic that there were 12 decisions taken by the court for enforcement or recognition of a foreign award, arbitral award in Poland. 11 of them were enforced. One only was denied enforcement. So I think this is a good number, and it shows that in terms of our system of justice, the climate for arbitration is really very positive. Thank you very much, and sorry for this, bad quality of my slide.
No problem at all. I saw your slides perfectly. You had to lean in a bit though, but that worked out fine. Very interesting. Thank you very much, Beata. Yes, I thought it was very interesting to learn that Poland had been victorious in this recent Energy Charter Treaty case, and they've been represented by the Ministry of Justice solely. Do you think that's a trend for Poland? Are there any indications that they will do their own legal work, so to speak? And it would also be interesting to hear from the Baltics how states handle representation in investment cases, whether they do it themselves or if they outsource it.
Well, if I may address this question, what was my observation is that in the smaller cases, well, maybe not even smaller, but in certain cases, I think that I don't know what is exactly the policy of the Attorney General, but I think that when they feel that they are strong, that they can make by themselves, they are running this proceedings. And I think that this shows that they have really pretty good expertise, and they have like a long-term expertise, because as I said, this is more than 20 years they are working on these cases, because the arbitration, they have the exclusive right to operate on behalf of the state treasury. But I think it's more complicated when they feel that they need some more support. They are inviting other law firms to support them and to represent. So I think that the door is not closed for us, the law firms.
That's reassuring. How is the situation in Lithuania, Ramonas, in terms of representation and investment arbitration of the state?
And generally in Lithuania, the state is a very good client for the law firms. The state represents itself before ECJ, no problem. It's very good quality of representation. The same is before European Court of Human Rights. But for investment arbitrations, and even for commercial ones, big cases, the state decides to hire the law firm, including international one. So Lithuania direction is a little bit different, and I've heard no information that the Ministry of Justice or any other ministry is considering change their way.
How about you, Daiga, in Latvia?
Hello. In Latvia, the state is usually represented by the state chancellery, which over the last 15 years has developed considerable knowledge, experience, and their team. And they are very successful in work what they are doing. And usually, if it's necessary, they involve international law firms to support them, to assist in investment disputes.
And Maria, Estonia?
Well, in Estonia, we have historically only had 5 investment arbitrations. So it would be an exaggeration to say that the state is a very good client for the law firms. However, the 5 we've had, if I'm not mistaken, then in 4 of those cases, international law firms have partnered up with local law firms. And in one of the cases, it's currently a local law firm that's representing the state. There's always a public procurement, so the law firms will have their fair chance of fighting for the case.
So from a law firm perspective, I guess it's not all bad news. So moving on, well, since you're speaking, you might as well continue, Maria. Well, first of all, thanks to Beata. And Maria, I understand that you're going to say a few words about the current arbitration boom in Estonia.
That is correct. Beata, thank you very much for giving us an overview about investment and commercial arbitration in Poland. I will proceed with not specifically discussing the arbitration content in Estonia, but giving you a bit of a background information of what we are seeing happening on the market. So let me start the presentation. I hope everyone is able to see it. And the topic is arbitration boom in Estonia. Notice how the voice is going up, so it's more of a question than a statement. By the end of the presentation, I'll leave it for each and every one of you to decide whether there's actually a boom or what exactly is going on. But to get started, so what do we see happening in practice? And when I say we, I don't mean only Sorainen. I have had discussions with my colleagues from other law firms, and the thoughts I'm sharing, a disclaimer, while they are my own, I've used their input. So I hope it provides you with an understanding of the market a little bit. What we see happening is that there is an increase of arbitration specialists who have entered the market. There is no specialized LLM program in arbitration in the Estonian universities. In fact, we don't even have a historically developed course for arbitration. However, in the past 2 years, and I think this year is the 3rd year, we have one class offered in the University of Tartu about arbitration, and it's led by 2 practicing lawyers. The feedback we've received from students has been amazing. So my virtual thank you goes out to those 2 lawyers who are leading the program. And we see that there is eagerness from the young lawyers only entering the market now to go and study abroad. And we've seen that in the past 5 to 10 years, the specialists who are now counseling and representing clients have their experience working for international law firms, doing their LLMs, working for institutions or for larger corporations. And what they bring back to Estonia is invaluable, because a flower cannot bloom unless someone keeps watering the plant. And this is what we see happening with the newly qualified lawyers who have some educational background in arbitration and experience as well. They bring back their knowledge, know-how, skill sets, and they help raise the awareness of the market in total. We also see that top law firms are frequently partnering up with international law firms to work as a local counsel or co-counsel. And why is this important? Well, I remember a story from 2012 when I was working on a case and I noticed there was an arbitration clause. I discussed it with my supervisor and we saw it's an SCC clause, the seat of arbitration in Sweden, and the hand immediately started to pick up the phone so that we could call someone in Stockholm and offer them the case. Why? Because it was rather standard that if you see anything even remotely related to foreign law, foreign jurisdiction, you get a little bit scared and you believe that the best solution for the client is to involve someone else. Now, this has changed. In Estonian market, all practicing lawyers now know what is the difference between a seat of arbitration, applicable law, what are the SCC rules or other rules and so forth. And today, and in the past 6-7 years, it's very frequent that when we receive a case and we have been with the client, we are their trusted advisor, then we do want to see the case developing all the way until the end once the dispute is over. So we would be acting as a lead counsel, a local counsel or co-counsel, depending on the specifics of the dispute. What we've also noticed is that there's a switch from court jurisdiction to arbitration in the M&A, real estate, construction, and transportation contracts. And this is, of course, not a closed list. There can be other contracts as well. And there are 2 reasons for this. Number one, there's still a continuous increase of foreign investment into Estonian companies. And in those cases, it's quite standard that you will have an international arbitration clause. But we have also seen that for domestic contracts, the transaction lawyers now prefer including an arbitration clause. And why? This has got a lot to do with how long litigation takes in Estonian courts. Normally, the first instance dispute would be over within a year. If it's a more complicated case, probably 1.5 years, 2 years. But if you include the appellate mechanism, then the dispute can last for 2 to 4 years. In complex cases, even 5 years. And frankly, you all know that the clients simply get sick and tired of being stuck in court instances. And Estonian Domestic Arbitration Institution, their rules say that the dispute has to be over within 6 months after the case file is referred to the tribunal, and they are pretty strict with this rule. It's rarely that this time gets extended. So the clients see a great benefit to opting for domestic arbitration versus domestic litigation. And another reason why arbitration is becoming more preferred is because we know that the awards rarely get annulled. Back in 2016 and 2017, there were a lot of pocket arbitrations happening where you would have fake institutions conducting their proceedings within a few weeks. The defendants would never hear of the claims that have been submitted against them. The Supreme Court made it clear that this is not okay. And while the circuit courts did struck down those arbitral awards, they almost never otherwise side with the applicant and almost always agree with what the arbitral tribunal has ruled. So we do feel fairly safe and secure counseling the clients that once we have the award, it's rarely annulled. And the same applies for recognition and enforcement. In Estonia, we have never had a foreign arbitration award that has not been recognized and enforced. And that tells a lot about the general climate of arbitration in Estonia. So moving on to see a little bit of the numbers. I was able to collect some data from the Code of Arbitration of the Estonian Chamber of Commerce and Industry, and also the SCC. Unfortunately, some other institutions were not able to distill their data from the databases for today, but I hope those numbers say something. Now, of course, if you look at the table, then everything I just told you will sound like an illusionary tale, because the numbers tell a different story than I just told you, especially if you look at the Code of Arbitration in Estonia. In 2017, 22 cases, and then year by year, there has been a bit of a decrease. However, does this mean that we don't have a boom? I would disagree here. And why? Because while the domestic arbitration cases seem to have a bit of a decrease, it's the international cases where we have seen an increase. And in addition to SCC, there are cases that are being referred to Helsinki, London, Paris, Zurich, Vienna. So if you could imagine a bigger picture behind that slide, you would soon realize that the association that the Estonian arbitration market currently has with all of the international practitioners very greatly impacts on the overall case load statistics in practice. So while we may not have a fully blossoming flower of arbitration currently, I do think that the seed is being watered, and in the coming years, once we have even more fully qualified and fully acknowledgeable arbitration lawyers entering the market, the client awareness continues to rise. There will be more work for lawyers and institutions. And with that, I conclude. Thank you.
Very interesting, Maria. Thank you very much. So I almost sense that your theory is that the increase in arbitration is being driven by the law firms, and in particular by people like yourself who have received training in arbitration and who are, how can I say, pro-arbitration, enthusiastic for arbitration, and have managed to convince clients to go for arbitration. Is that correct?
Oh, absolutely. But I would add that it's not only the former students who've had the education. We do have a lot of great practitioners who may not have an LLM degree abroad, but who are very interested in arbitration practice, who have acted as arbitrators themselves, who have a longer career where they've seen what are the benefits of arbitration versus litigation, and we cannot underestimate what their impact on the market is. It's the contrary. It's the generation that's not educated abroad in combination with the generation that now is, who helped taking this arbitration practice further.
Another just observation on that, and this is just a personal reflection from Russia and my experiences there. I've seen a massive growth in in young lawyers and applicants, people wanting to work with arbitration. Some become a bit disappointed when they realize that maybe the arbitration market is not that big. Everyone can't work with international arbitration. Some people have to do litigation and so forth. Do you have similar, you know, how do you deal with students and their new employees and their expectations, you know, about working in this exciting field of international arbitration, which may not always, you know, there may not be enough cases, right?
Well, what I like to say is that there may not be enough cases yet, meaning if you truly do feel like you have a gene for arbitration and you keep going, you have to develop the market. It's more fascinating if you get to be part of the process rather than entering the market once it's, so to say, fully functional already. And working as a litigation lawyer and then doing arbitration as well is a great benefit. So I think the students do see the value in that.
Thank you very much. Moving on then to Daiga and Latvia. And I understand that in Latvia, there's arbitration reform on the horizon. There's been a lot of reform in the last 5-6 years, I understand, but there may be even more reform on the horizon, correct?
Yes, it's so. Good morning, all participants and speakers, and thank you to the organizers and Frederick for kind introduction. I'm practicing in Latvia, and I would like to talk about the arbitration reform in Latvia, what was achieved, and what are the current needs. And in the second part of my presentation, I would like to share my view about the newly established economic court that could be an alternative or possible support to arbitration. I'm glad to say that the real estate and M&A market is blooming in Latvia, and it means that the corporate clients raise questions about arbitration clauses and where to solve potential disputes. In the state courts or in arbitration, in Latvia or in other countries. We very often are asked to recommend arbitration institutions close to Latvia, which are reliable and could solve their disputes in a very fast and understandable way. For this reason, very often the companies decide to include arbitration clauses on dispute resolution in Stockholm, Helsinki, or German arbitration institutions. Of course, as lawyers, we would like to recommend more domestic arbitration institutions, and we see that our clients are more and more interested about arbitration in Latvia. At the same time, they have experience and memories about the previous years, when Latvia had too many arbitration institutions, more than 200, with big questions about the quality. After the reform in 2015, the number of arbitration institutions is considerably reduced, but still it's too high. Currently, more than 50 arbitration institutions are registered. We can say that the first goal was achieved, and now, after 6 years, we see that the needs of the business community show that substantial changes are needed, how the disputes are examined in arbitration in Latvia. It has a direct link to the quality and trust to domestic arbitration. Unfortunately, ancestral model law was not introduced during the previous reform, despite of recommendations of practitioners to choose this approach. After 6 years now, again, we come back to the same conclusions that we need to use the same principles that are already tested in other countries. For example, in our neighboring country, Lithuania. Currently, we observe that the parties agree on domestic arbitration if they foresee that their dispute can be examined based on written evidence. But when it comes to the witnesses, for example, this opportunity is not available according to the Latvian arbitration law. The same relates to the other needs of the parties. For example, the request arrest of assets or other interim measures to the general jurisdiction courts. The procedural and arbitration laws allow only to request preliminary measures before the submission of the claim. Considering limited regulation, the companies evaluate very carefully what kind of disputes they will potentially have and what evidence will be needed and available before agreeing to include domestic arbitration clauses in their contracts. And here I see a wonderful opportunity that newly formed economic court, which started work in the end of March this year, could be the specialized court to support the local arbitration institutions and to undertake specific procedural functions. For example, to summon witnesses, perform witness examinations, document testimonies for submission in arbitration, or examine the request for interim measures before or during arbitration proceedings. Decide on setting aside of arbitral awards when it's requested. Currently, control of arbitral awards is performed only in the enforcement stage by the state courts. According to judgments of the Latvian Constitutional Court and Supreme Court and related amendments to the civil procedural law, the party can dispute the validity of the arbitration agreement in the state court in any stage of the case or even in the enforcement stage when examination is already completed. On the one hand, it provides protection if arbitration is used improperly. But on the other hand, it creates instability and influences trust to domestic arbitration. As I mentioned, the new economic court started its work this spring with purpose to examine business-related civil disputes and white-collar crime cases in improved quality and speed. The civil procedural law provides that this court decides also on investment protection claims of the investors coming from the EU countries. This amendment to the law is a very quick step and reaction of the Latvian government and parliament following the Acmea case and termination of intra-EU bilateral investment treaties by Latvia and most of the EU countries. As far as I am aware, there are no such cases filed in the specific court. At the same time, this procedural regulation raises questions whether the EU investors in Latvia will feel comfortable with this opportunity and will receive adequate protection. These topics are in development, and I hope that most reasonable solutions will be found both for the domestic arbitration and for the investment disputes. I will conclude on this optimistic note.
Thank you very much, Daiga. That was an optimistic note. Do I understand correctly that the economic court, this newly founded economic court, that it does not currently provide assistance in commercial arbitration, but that this is rather something you wanted to do, that you proposed that it do, or?
Formally, it's already included in the procedural law. Formally, there is the framework, legal framework to file a claim on investment disputes. But of course, we, as practitioners, we have very big question mark about reliability and how investors will perceive this opportunity, because the same court examines also the business disputes. It means that it could be a situation that the same court examined a dispute in Latvia that is very closely related to this investment dispute. And again, the next instance, the appellate level court, will be the general jurisdiction court, the state court, which examines all civil disputes. So here are some questions which shall be solved in next months or even years.
Have the judges at the economic court been recruited having regard to a particular kind of background expertise? Are they people who are familiar with commercial cases?
Yes, the selection procedure was very careful, and it was the first time how the judges, new judges for this economical court judges were selected. And of course, they come from different areas and with different backgrounds, but we hope that they will have this bit more business attitude and business thinking about this type of cases.
So I guess in view of the issues you've had in Latvia with too many arbitration institutions, you still have it today to a certain extent. Can the economic court be seen as an attempt by the Latvian government to kind of make court proceedings more appealable to parties, more attractive, I guess?
Yes, exactly.
In competition with arbitration institutions.
Exactly. This is the purpose, to make more attractive this opportunity to agree on dispute resolution in state court and to rely more on state courts in Latvia.
Thank you very much. So the battle between litigation and arbitration is also being fought very intensively in Latvia. And then we can, thank you again, move to Ramūnas and Lithuania. And I understand that Ramūnas will speak about the case in which he was involved himself before the Lithuanian Supreme Court, relating to the ever relevant issue of the scope of public policy in terms of recognition and enforcement of arbitral awards. Please, Ramūnas.
Thank you, Frederick. I'm trying to find my presentation, which recently disappeared from the screen. My apologies for...
No worries. Take your time.
I hope you see it.
Well, we see your computer, I guess, your file system, and there you have recent files at the top.
All right. That means you don't see anything.
I think you need to select that. Otherwise, I think maybe if there's someone on the SCC on, if Fabian is on the call, maybe he could share the presentation.
Strangely, doesn't work.
Ramūnas, I have your presentation open. Would you like me to share it? And
Yes,
you can
please.
tell me when to switch slides?
Yes, please.
Another example of Baltic cooperation.
Ramūnas, you have to stop sharing first and then I can.
Yes, of course. Strangely, it is locked. Oh, it's good.
No, it's fine.
Thank you for your patience, guys. It's first time during 2 years of remote working, Zoom is not in line with my actions. So let me go to the generally boring stuff, like public policy, which is not the boring stuff in Lithuania when we come to the Supreme Court. And there was a ruling from the Supreme Court in April this year that changed the law practice and expanded the interpretation of public policy when it comes to staying the arbitration award aside. And before we go to the problem deeper, I would like to browse around the facts of the case that are already disclosed by the Supreme Court in the ruling. There was a settlement agreement between arbitration creditor and debtors. Creditor was seeking for the debt payment, while debtors filed a claim in Vilnius Court of Commercial Arbitration to annul the settlement agreement with arbitration creditor. Litigation creditor, which is a different creditor and not a party to arbitration agreement, filed actio Poliana, a creditor's claim in Lithuanian court, to declare the same exact settlement agreement invalid. Parties to arbitration were involved as respondents in litigation. Arbitration creditor filed a counterclaim in arbitration to collect money and, let's say, won the arbitration case. Tribunal rejected debtor's claim and ordered debtors to pay money, while parallel litigation continued. Could we go to the next slide, please? Debtors started the case in Lithuanian Court of Appeal to set aside the debt award, inter alia involving public policy matters. Court of Appeals rejected complaint, finding no public policy violation. However, afterwards, in parallel litigation, the court declared the settlement agreement invalid. Debtors appealed, of course, and this exact invalidation judgment didn't come into force. Moreover, this exact invalidation judgment was not enforced when debtors submitted cassation claim before the Supreme Court of Lithuania. As I understand from the Supreme Court ruling, procedural successor to arbitration creditor decided to discontinue the appeal proceedings regarding invalidation judgment, and therefore invalidation judgment entered into force with immediate effect against the parties to settlement agreement. What the Supreme Court had on the table when the hearing started, it had invalidation judgment that is already in force, and debt award that is being challenged in a court system. The Supreme Court needed to decide as to whether the later event, invalidating judgment, employs a public policy ground to set aside the prior debt award. Actually, Lithuanian law didn't provide a clear answer. Interestingly, Supreme Court concluded that there was no violation of public policy at the time when debt award was rendered. Moreover, the Supreme Court then to conclude that there were no grounds to apply public policy at the time when the judgment of a Court of Appeals was announced. However, the Supreme Court decided that parallel litigation and arbitration created, in the words of the Supreme Court, a risk of coexistence of conflicting decisions in the future, and recognized that Lithuanian law does not provide any mechanism to avoid this risk. Is there anything new? I would say majority of audience would say there's nothing new. It could be parallel litigation or arbitration. However, according to the Supreme Court, such risk must be managed and must be managed by involving essential procedural principles. The Supreme Court went to elaborate on how this problem is resolved in court system. It means in the system which is under the skin of honorable justices in their daily routines. It's undeniable. Reopening of a court case, according to the Supreme Court, resolves the problem when two conflicting or incompatible court decisions are present. However, there is no possibility to reopen an arbitration case, according to the Supreme Court in Lithuania. The Supreme Court recognized that universally accepted procedural principle to avoid conflicting or incompatible court decisions is a part of international public policy. And you understand what was the direction of the Supreme Court to deal with two different decisions that were on the table of the Supreme Court. And therefore, Supreme Court concluded that incompatibility of a debt award with an invalidation judgment is contrary to international public policy and decided to set aside a debt award. So what the conclusion, what was the interesting mind of the Supreme Court that was never existed before? the Supreme Court extended public policy to the events that didn't exist at the time of the rendering of the arbitral award. So it means that prior award ordering the debtor to pay the money does not guarantee the result if the court later annuls the agreement which the award was based on. So this is the new development of public policy, which is important in both cases when you challenge the award. And the Supreme Court in this case made interconnection with New York Convention and the grounds for recognition and enforcement. So public policy in Lithuania now has a different quality that it had before April 7, 2021. And it doesn't mean Lithuania became hostile country for arbitration. Of course, it is very good country. It has very good infrastructure, but legal regime that is on the table didn't provide and does not provide any possible outcome when two conflicting awards and judgments are in the same legal system. So therefore, the Supreme Court had no other choice but to go this direction of interpretation of public policy. That is my conclusion. I'll be happy to answer questions. Answer all questions from the panel and from the audience.
Very interesting, Armunas. A complex case, interesting procedural situation. I'm sure it was a case which was almost a dream come true for a person who loves procedural law. You get involved in all the nitty-gritty. But one thing I thought about was, were there any discussion in the court proceedings, in which the invalidation judgment were rendered about the award? I mean, the fact that there was an award and that there could be, that the effect of that lower court judgment could be inconsistent, somewhat inconsistent rulings.
The main part of the proceedings were confidential, not only arbitration. So there is not much public information regarding this case and the parallel litigation. However, I know that the parties who represented, the counsels who represented the parties in this big dispute are present in this audience. They can comment and elaborate as much as they can, and not prohibited with professional secrecy. However, I would say that the court didn't go deeper into this question like you asked, Frederick. I mean, the Supreme Court, where ruling is public. And the main moment for the Supreme Court, which was related to the public policy, was coexistence of two conflicting decisions that are enforceable in the same legal system. And one decision is from the tribunal, the other is from the court, and the court made priority to the court. There's nothing strange, nothing surprising that the court says that the court goes first. And
but there were different parties, right? There were not overlapping parties in the two proceedings.
No, there were some parties overlapping, and of course,
the
litigation creditor, the plaintiff, was not the party to arbitration.
What kind of legal action was that? I mean, you call it something actio polianis or whatever. So this is an action under Lithuanian law which allows a non-party to an agreement who has some kind of economic interest to declare it invalid.
Yes, it is the claim from the creditor to one of the parties to the agreement to claim this agreement invalid. This is creditor's claim. It's
like
typical creditor's claim.
Clawback claim or something like that.
Similar.
Yeah. Okay. Okay. So in that case, the arbitration agreement was not considered to be an obstacle, so to speak, in that context.
No.
No. Well, very interesting. Is there any? I understand you view this as a very specific case, which does not maybe say so much about. You say this is not really indicate a trend towards an expansive view of public policy in Lithuania, but you view this as somewhat specific. Or is there a trend? I'll just ask you the question. Is there a trend in Lithuania in the state courts towards a more expansive view of public policy?
No, I don't think so. I don't think so. Lithuanian courts, including the Supreme Court, are very friendly to arbitration, and all interpretation is pro-arbitral, and the system didn't change. And I think that direction of Lithuanian legal mind at the level of the Supreme Court didn't change either. That was just an application of the law and the general principles to this exact situation. That's it. So therefore, that is my personal opinion. The Supreme Court didn't decide to go for extended panel to 7 members. There were only 3 members making this judgment. So I see no direction, no policy changes, but however, we should take into consideration when dealing with similar issues here in Lithuania.
Thank you very much, Ramonas. I think we've been going on for about an hour. I don't know if, but we do, I think, have 10 more minutes according to the schedule. We started a bit early. Do any of the other panelists want to weigh in on maybe public policy in your respective jurisdictions? Any trends, any worrying or hopeful signs? Maria?
Yes, well, I can comment that in Estonia, the Supreme Court has never found that public policy would be, that there are facts which support that under the public policy exception, an award should be annulled. However, the Supreme Court has said that, for example, under circumstances where there would be an arbitrator who later becomes a party representative in the same case, this may constitute a conflict that would go against Estonian public policy. But this particular case eventually was decided that the facts did not support this, this proposition. So based on the practice, I can't give you any examples where we can say that this specific case under those specific facts means there's a contradiction with public policy.
Thank you, Maria. Anyone else wants to?
Yeah. I think I was recently, dealing a lot with public policy, but in terms of substantive law. It means whether the public policy violation, how it can be really effectuated in the area of the substantive law. I think that in general, if you are talking about Poland, as you have seen, there's not too much words to be set aside. So this also applies to the public policy. I think that this is by definition very vague. It means what does mean public policy? So it is subject to many interpretations. Depending on this, how much friendly is the given jurisdiction, the interpretation is more or less strict. In general, in this area of the substantive law, we are usually facing such really basic principles like pacta sunt servanda, like action in good faith. I recall the such premises grounds like there is that the compensation was granted, however there was no damage proved, so that was elevated to the level of the public policy violation. But it does not happen too often. The case, what I was talking about, this invalidation of the agreement, that was also reaching the arguments relating to public policy, that it is because this is depriving the party from the possibility to present the case, and that was not treated as a public policy. That was treated much more as a kind of a business risk when you're entering into the arbitration clauses. What I was thinking about, maybe the case which was presented by Ramonas. I was thinking how it related. I don't know. I understand that they were not exactly the same parties, but I was thinking what happens with the principle of res judicata in this case, because we had 2 conflicting awards, which I understand that they were really applying to the same to the same legal relationship, basically. I understand what is actio Pauliana, that this is the third party who is attacking the existing relationship. But I started to think about it, and probably Ramonas, you have more thoughts about that, whether that was any area of introduction, this kind of argument. It means based on the res judicata in this case.
I see now my personal view. It's my personal view. The grounds to challenge, the grounds of challenge based on actual Polyana, and the grounds of challenge of the settlement agreement in arbitration case were different. So there was very new, very fresh, and very different attitude from the litigation creditor. I think that, first of all, the court didn't go into this. Neither Court of Appeals nor Supreme Court decided that there is an issue of res judicata at all. And having no res judicata at all before Supreme Court, the Supreme Court made the decision as this. So I do not think that the parties involved this moment, but I do not think that the parties were focused on this.
Okay.
A public policy issue becomes an event in all our countries, including Poland, when it comes to investment arbitration, where we started with Beata. It could be public policy extension when we speak about recognition and enforcement of non-ICSID awards issued under bilateral investment treaties in any country of ours. And when it comes to ICSID award, it will become even more complicated issue.
No doubt. I see we received one question from the audience. Hi, thanks so much for detailed information about the arbitration in Poland and Baltic states. Taking into consideration the fact that all Baltic states are post-Soviet states, let me see here. Could you please clarify whether they have been more successful than other post-Soviet states in the process of integration to the international norms regarding arbitration after their independence in the 1990s. Do you think there is any conflict between the New York Convention and the national legislations of the Baltic states, I guess, in terms of arbitration? That was a long question, but and two questions, I think. But let's start with the last one. Is there any conflict between the New York Convention and the arbitration legislations of the Baltic states? Do you want to begin, Ramonas?
Yes, I see no conflicts, and I see very good integration of Lithuania into international community, including public international law, and the competence of justices in Lithuania to apply it. And I'm very happy for my country that the country is moving very well in terms of application of international public law in the courts, and in terms of the friendliness of the courts to arbitration and support. So I like what is going on, notwithstanding this exact the Supreme Court ruling, and I treat it as very positive, and I'm proud of my country.
Daiga, how about you in Latvia?
If we talk about New York Convention, then formally Latvian courts observe these principles and rules. The difference could be in arguments and evaluation. For example, the recent tendency is to use the public order argument in case when the arbitral award includes very high contractual penalties. And then the state courts find that it's contradictory to the Latvian regulation. This is the main aspect what I can imagine.
Thank you, Daiga. Do you want to weigh in there as well, Maria?
I hope everyone can see the written answer as well, but sure, I will confirm that Estonian court practice has never identified a conflict. We are party to the New York Convention. The Code of Civil Procedure specifically refers to the convention when we recognize and enforce awards. And from my perspective, the Foreign Counsel may quite comfortably advise the client that the award will be nicely recognized and enforced in Estonia.
Okay, I guess the question related to the Baltics, and Poland was excluded. Beata was excluded from this question, but if you want to weigh in, you're welcome to do so.
I think that we have pretty good alignment into the international framework. New York Convention is regularly adopted. We are the model law jurisdiction, and we have very, very narrow departures, very insignificant departures from the model law. As I said, the ratio of the dismissed recognitions is very low, and the general atmosphere in the courts, in the state courts, is very good, as we say, friendly to arbitration. And I think that is also visible in when I was watching how many times the Warsaw is appointed as a place of arbitration. And as I was in ICC, I was following this thing, and I think that this is more and more. Warsaw is a place for arbitration, so it shows that the infrastructure for the jurisdictional choice is positive.
Okay, I think we've just now run out of time, so it's very good timing. And I want to thank all of you for participating and offering your insights. And I guess I'll leave the word to Natalia or Ginta.
Thank you, Frederick. Thank you very much, everyone. We received a couple of questions, and now they have been answered. And Maria also managed to answer another question specifically with respect to Estonian law in the chat. And I think it's time now to leave the floor to Eva Kalniņa and Ginta Arel for their inspirational talk about international arbitration.
Thank you very much, Natalia.
Thank you.
Good morning. I will start by saying on behalf of Ginta and myself that we're grateful for this invitation to participate in a seminar, and we're also grateful to the SCC for giving us freedom with the topic, the main condition being that it needs to be inspirational. So we thought that we would begin by sharing with you our own personal journey, and then discuss the way that we have watched arbitration world change in the last 10 to 15 years, and particularly after COVID as well. We can't leave COVID out. We will then share with you some of our COVID takeaways and conclude by making some observations on arbitration in the Baltics and Poland. We have also seen the list of participants and noted that we have a number of relatively more junior practitioners joining us today. So we have tailored our talk with our audience in mind. So starting with the introduction, somebody told me the other day that my personal arbitration journey resembles an arbitration fairy tale. And I was grateful for the compliment, although I'm not sure about the fairy tale part, given the number of hours spent hunched behind my laptop. Doesn't seem more like a hunched elf than a princess. So that said, it is true that I've had a very international upbringing from an early age on. And already during my high school years, I lived in several different countries on various scholarships and exchange programs, which were available to Eastern European kids really in the 90s. That's probably due to my parents' frustration, who had to spend the good part of their lives behind the Iron Curtain. And so they pushed me outside the Latvian borders quite early on to see the world, so to say, and learn different languages. And then came back to Latvia for my basic law degree, followed by a master's at the European University Institute in Florence and an LLM at Harvard. I passed the New York bar exam and started working at a big Italian law firm in Milan, where I acted mostly as counsel in investment treaty cases. But 15 years ago, Italy was a different place than it is right now. And it was certainly not the best place for a woman, especially with a foreign law degree, to make her career. I was also not encouraged by the fact that at the time, out of 50-something partners, there were, and you can guess, 2 women. So very different from the statistics that Aku shared with us earlier today. After 3 years at Vanelli, I decided it would be good to see arbitration also from the arbitrator's perspective. And so I moved to Levy Kaufman Kohler in Geneva and started working as a tribunal secretary for Gabriel Kaufman Kohler and Laurent Levy. It was an excellent experience, and again, something that I would recommend to any young practitioner. But of course, I also started worrying about this possible transition from the secretary role to that of an arbitrator. And I was approached at times by law firms to join them as associate. And as I kindly declined those offers, I was once asked, so you're going to be a secretary your whole life? Which hurt a bit, even though I, of course, enjoyed doing the work that I was doing. And then just as I began to despair, I received my first arbitrator appointment some 6 or 7 years ago, followed actually by an appointment by the SCC as a chair in a large and complex case in the Russian language. So this was a breaking point for me. So really, I am grateful for the trust. And at the time, there was no pledge. There was not as much intention for sure for the need of diversity in arbitration, and particularly female arbitrators. So those were different days, and this is certainly one way that the world has changed for the better. And with that, now Ginte will take over and share her experience.
Thank you, Eva. I was listening to you and also thinking about where did it start and how did it start. And in my previous life, back in Riga, I had no international upbringing whatsoever, and in fact, I never contemplated leaving Latvia. I worked for Ericsson, which is a Swedish company with marketing and sales and project management. I did study law at evening classes in the University of Riga, but at the time that was, I don't know if we can say that I studied law. I think I read the history of law for 2 years or something, because it was just on the verge of changing, in the early 90s. And then I met my husband, and then I moved to Stockholm. And thereafter, having spent a couple of more years with Ericsson, I decided to pursue the law career. So I went to the Stockholm University and took the exams in Swedish language and was sitting there with my dictionary and translating all the Swedish terms into English and then trying to figure out what do they mean in Latvian. And so, but it went well. And after the law school, I went to the law firm. And much like Maria was telling earlier today, at the time, there was virtually nothing said about arbitration, even in Swedish universities. And apart from the advanced courses, so I took one of those advanced courses in arbitration and realized that this is the pretty much only area of law in Sweden where I'll be able to use my background and language skills. But at the time, arbitration in Sweden was very closed shop. There were quite a few practitioners, but it was still a very difficult area to get there. And I was once told that, well, if you want to do arbitration, you first have to do a great number of years within litigation, and then you might eventually stumble in an odd case as counsel in arbitration. But so it took me 5 years or so to get into a dispute resolution group that actually did arbitration. And once there, then I felt at home. And also very much thanks to my mentor and Nestor, who gave me responsibility and gave me opportunities to act as lead counsel, for example, and that was in the case in Russian. That's where half of my gray hair comes from. And then I'm, as pretty much the same as you, I'm very grateful to the SCC who gave the first appointments, also the cases in Russian. That's where the rest of the gray hair comes from. So Russian became a unique selling point for me and a very good stepping stone into the arbitration world. So now I'm with the firm that is specialized only with dispute resolution and intellectual property law. And my primary focus has always been as a counsel in arbitration, but now it's changing steadily, and I'm receiving more frequent arbitrator appointments. And that would not have been possible without the SCC's striving to diversify the community, to open up that closed shop. And also that what brings us to this discussion here is that, and also was said earlier by Aku not least, that the flexibility we have today in putting together our private lives and our careers is much greater than we had before. And I know, Eva, you changed your firm recently as well. What was the driving factors behind that, or your reasoning there?
Well, in part, it's the desire to seek out new challenges. 12 years is a long time. I'm not very adventurous in that sense. I think I've been quite stable, for better or for worse. I think for the better. Of course, our arbitration world is also changing. As arbitrators, my fellow arbitrators will know, conflicts of interest, for example, is a big issue. Essentially, we're operating a bit in a legal vacuum when it comes to identifying conflicts. Now, of course, it is an exaggeration to say there's a vacuum. We have the IBA rules, we have guidance from institutions, but there's certainly not enough clarity. And as a member of the ICC court, I also often see and the very intense debates whether a challenge should be accepted or not, that it's certainly an area where more clarity would be appreciated. So, and finally, I've now put down my counsel hat for good, with a little bit of sadness, because I did also enjoy acting as counsel, although that has never been my primary activity. And I'm looking forward to this new chapter. COVID as well certainly has contributed to new ways of doing things, and the learning curve over this past year has been very fast, as we all know. I won't spend much time on that because there have been so many online conferences dedicated to virtual advocacy, and a number of arbitral institutions, including the SCC, are there to provide guidance on managing virtual hearings. But I will just say, in the context of our present talk, that certainly when I started practicing arbitration some 15 years ago, it was very customary for the first procedural meeting to be held in person. And then sometimes gradually it changed to telephone conference calls. But I think now post-COVID, and thanks to the quality of video conference facilities as well, I think it is by now accepted that nobody will be getting on a plane to conduct or almost nobody, I should say, to conduct the first procedural meeting in person, irrespective of whether you're conscious of your carbon footprint or not. I think initially as well, there was this debate and the two fronts of lovers and haters of virtual hearings. I think it is by now widely accepted that virtual hearings are time and cost efficient, and in the wide majority of cases, although not all cases, provided that they're done properly and your internet connection works, they are here to stay, and they will be working just as well as in-person hearings, especially in light of the fact that over the last year, courts in a number of jurisdictions have confirmed the tribunal's power to hold a virtual hearing over one party's objection. And again, I can refer you to a number of studies on this by ICA and Queen Mary University, and this is the case in most jurisdictions. So arbitrators too are on safe ground to order virtual hearings, and there's no place for due process paranoia. So very briefly, with this in mind, just my couple of takeaways for a successful virtual hearing, given that this is what we will see more in the future. Well, first of all, we have all learned the importance of setting out clear procedural rules and hearing protocols in advance, so as to avoid any surprises on the day. Issues such as confidentiality, sequestration, cybersecurity, who is in the room, how do you make sure there's nobody else in the room but the witness if that's the case, etc. And also procedural timetable sensitive to time zones. So here the ball is really in the tribunal's court, but as counsel, again, and should you have a more passive tribunal, do not hesitate to make your own suggestions, I would say. Now, second point is that I think we have to accept that overall the power to influence people through oral advocacy may be slightly diluted in remote hearings. There's, again, a lot of debate about it. Some argue that the fact that you can see the witness's face very close on and every gray hair and wrinkle somehow makes the testimony more reliable. Nonetheless, I think there's something to be said that it's tricky. And therefore, my only tip would be that clear written submissions and well-drafted and comprehensive skeleton arguments are more important than ever. And this applies in particularly to cases where facts play a key role. So advocates should be aware that some tribunals may find the value of oral testimony to be slightly diminished in a virtual setting. So let's not forget about the human aspect, which then can be recreated in written witness statements, for example. And then my final point is to be creative and to use technology to your advantage and not only disadvantage, because despite the fact that we can do everything faster, we don't need to travel, we can save time, at the end of the day, we have less and less time for everything. So being creative, what I mean by that, for example, pre-recorded opening statements that the tribunal can watch at their own leisure. If hearing time and different time zones are involved, I've seen this in a couple of cases, it has worked well. For example, taking a day off before closing statements. It was usually the case in-person hearings that everybody had to rush home, it was Friday night, etc. Now that we have more flexibility, we can actually take a day off before these closing statements, make them more comprehensive, and in turn, this could spare the need for post-hearing briefs, perhaps, and also reduce the number of submissions. I think INTA also has something to say about the growing complexity of arbitration in the recent years.
Well, it sounds like you're almost talking about arbitration Netflix, you know, it's like send in your more pre-recorded movies and we'll watch them when we have time. And it's amazing to see what the technology can do and how much of this is technology driven. I mean, our flexibility rests on the possibility to work anytime, anywhere. And earlier during the sound check today, I think Frederick asked, so how's your summer been? And I hesitated to answer because on one hand, it was a great summer. I spent a lot of time in Latvia. And then on the other hand, it was not a great summer because every night I was sitting there, you know, working on various cases. So, but looking back, I mean, I think only 7, 8, 10 years back, that would not have been possible. And keep that thought, Eva, and we can talk about the motherhood later, perhaps. But that's another area on where do you draw the line when you are available virtually anytime, anywhere. It's even difficult to go to the Swedish mountains and say that I don't have any coverage there. Please don't call me because I do. But that's a different topic. If we go then, or you want to pick up that one?
I just wanted to say I have a friend who goes sailing, and then she really does not have coverage. But it's true, the mountains are no escape anymore. You now need to resort to the high seas.
Yeah, But that is also the issue with the complexity, and we talked when preparing for this discussion on there is a tendency or a trend for the cases getting bigger and more complex, or maybe that's just a function of us being more experienced and getting on the big cases. I don't know, but certainly that could be a general trend as well. And the question is, who's to blame for that? Because I think most of the people would agree that it's not for the client's interest, because the longer submissions you write, the more exhibits you attach, the more witnesses you hear, the longer and costlier and the proceedings will be. And so I also think most of the people will agree that that's a council-driven issue. But as a counsel, I have to speak up for my fellow counsel as well, that I'm not entirely sure. I mean, to the extent that is a council issue. But I think it all stems from the access to information that we have today. We have an enormous, often we have there's enormous email correspondence databases for a number of years between hundreds of people. We have very easy access to legal authorities. So parsing through all of that, it gives you you can amass a base of evidence and legal authorities that you were not simply able to do previously. And so, and of course, from the US, we have the other driving factor, which is unfortunately the deep pocket syndrome, when there's a certain temptation to sue your counsel for misconduct if the case goes south. But I would like to return that question to you, Eva, and how, from the arbitrator's perspective, would you, or actually I have two questions. One of them would be, would you say that if we stick to the commercial cases, are they getting more complex from legal perspective, from procedural law perspective, or are they getting more, would you say they are more complex on the facts? And the other question is, how do you balance this as an arbitrator in between the right to be heard and the efficiency requirement you still have?
Good questions and a $1 million answer now. First of all, I think the cases themselves, on average, I don't think they're becoming more complex legally. I think it's more about the framework in which they're operating. So let's just simply take procedure as opposed to substance. Procedure order number 1, 10, 15 years ago, not all tribunals did one. Now it's a rule, it's a good thing. My first procedural orders that I drafted as a secretary were about 2-3 pages long. Now they're about 10-11 pages long. There's so many more things to cover. Where is this coming from? As an arbitrator, do you want to take the risk not to cover them? I think generally in England, there's still the trend of being overall shorter and more to the point than maybe in the civil jurisdictions. However, I think this is just simply our mindset has changed. So now the other question is, what can the tribunal do? We all know about the cost and the time and cost efficiencies, and arbitral institutions have done an excellent job providing very concrete techniques how to save time and cost in arbitration. But sometimes I do wonder for the benefit of whom, and is it really so that it's in the client's best interest? If it's, we all know, probably we've also had those difficult deep pocket clients that actually do not really care about time and cost. So, well, I think we can all agree that it's better for the system I'm not sure that we can attribute it to any one single entity in whose interest that would be. And where does that lead us? So as a tribunal, you're also sometimes in a difficult position because you know that you are operating under strict time limits. The time limits also imposed by the institutions, rightly so. No complaints, Natalia. But it is a fact, right? There was the 2-month, 3-month time limit for the final award, sometimes for proceedings that have gone on for 2, 3, even more years. And then, but how, now back to you, for example, page limits. There are several techniques that the tribunal can do, limiting hearing time, conducting, for example, a case management conference early on, having had a preliminary view of all submissions and indicating preliminary views, saying, we would really appreciate if you concentrate on issue A as opposed to issue B. We really don't think that this witness should appear because he's basically saying the same thing as the other 2 witnesses are saying. We will impose strict time limits at the hearing. I mean, we, at least my generation, I think, have been still brought up with the idea that it is the party's process. But we need to balance a number of different interests. So how would you feel, Ginta, with the tribunal telling you what to do and to really keep it short and no more than 15 pages for your post-hearing brief?
I'm happy with the post-hearing brief being short. I'm not much of a writer myself. I prefer to write short, but I would not be happy if you would impose that on the first or second round of submissions. But I would be very happy with the time limits in a hearing. That forces you to sort of boil down the case, and it often becomes much better hearing if there are strict time limits. But of course, that is all on balancing the right to be heard and against the efficiency. But my temptation as a procedural, as a counsel and procedural lawyer, I imagine having in front of me all my tools, like lazy knives and bone saws and whatever, scalpels and knives of various sizes. And then I come to the case and you tell me that I only need to use scissors and a hammer. I mean, I have all of this and I know how to use the laser knife, and should I not be able to do that? But eventually I think that we all have to, abandon our temptations and think about the client's best. And sometimes it is best to use just the scissors and nothing else. But if we are to follow through our outline, we have quite a few topics to cover in 3 minutes. And one of them is arbitration in Baltics and Poland. I think that's sort of the main thing here. So Eva, as an arbitrator, is there any particular behavior you would spot on in your experience that would pertain to the region, or something you like or dislike, prefer?
I think it will be a general point, and I think I will not be very original in saying this, is that most arbitrators really appreciate parties being cooperative and making genuine attempts, not necessarily to settle the dispute, because then we would be all out of work. No, I'm joking, of course, but to really discuss and settle any procedural matters among themselves and not engage in procedural aggression, where counsel are being aggressive just for the sake of it, to make a point, so to say, because ultimately it is time consuming, inefficient, and makes very little, has very little impact on the ultimate outcome of the proceedings. So I think fair game is very important, and being cooperative. And here, what I mean by it, with concrete examples, is, for example, objecting to very short time extensions requested by the other party, which have no impact on the procedural timetable, making a point that the files were transferred I don't know, a couple of seconds late or things like that. I mean, it is fine. As a tribunal, one takes these comments on board. They are made very often, in my experience. But as counsel, you just need to ask yourself what it is that you're trying to achieve. That would be just a recommendation.
Right, and from my perspective as counsel, then I would say that, and that's not much, you know, depending on a counsel, but rather on the clients, that there is a tendency to bring up alternative theories of why things have happened, and in search of a motive of why the opposing party is acting in a certain way. And it's kind of almost to the level of conspiracy theories, and they often presented but are almost never proved. Anything else you're thinking about in this area?
Well, I think another particularity of both Eastern European and CIS cases is, of course, the way businesses are structured, the ultimate beneficial owners, and issues such as piercing the corporate veil. Especially if local laws apply, because not all local laws actually have either sophisticated jurisprudence or in fact any provisions covering these type of situations. So one needs then to resort to more comparative studies. That's just simply one particularity that I have seen more often than not in the Eastern European CIS context. But I think it's time to wrap up. So Ginta, what would be your parting words? And
well, that is something I would like to go back to what Maria earlier said, and Fredrik also echoed, is that there is a great number of local councils that are getting, compared to 10 years ago, we see now that the local council are following their clients and representing as lead counsel in arbitration seated elsewhere and under rules abroad and so on, and they are very, very good. And if going back to what Fredrik was saying about younger people that would like to join the practice and now to some extent disappointed that they would have to do litigation and not arbitration, I would only like to say that a great litigator will become a great arbitrator or arbitration practitioner, because the difference between those two is not that big. It's just a matter of procedure. But if you have the basic skills from litigation, that will help you immensely. And yes,
well, I would echo that. Just to add, I would echo that and say that it always fills me with a little bit of pride to see how well local firms from the Baltics and Poland as well are doing. I've had several experiences in the past years, and I've been very impressed how professional and well prepared they are, and they're quickly catching up with Western European firms in terms of experience and quality.
But my sort of last famous word would be that, particularly for the younger practitioners, is that I think we are all very fortunate and very privileged to work in this area. I think this is, from my perspective at least, one of the most interesting and rewarding area of law. And it brings together people from global cultures, from legal backgrounds. We have to work out our, why do they say like that and stuff like that. It's really opening up your mind. And I understand that young people are attracted to that. And we see that also in our own practice, that given our niche on international arbitration, we have a lot of people, Swedish young people that are seeking that. And to the young practitioners, I would just like to say that work hard, aim high, everything is possible, but above all, enjoy, because the flexibility may kill you if you don't watch out.
Make the flexibility work for you, because ultimately what we all need is more time to savor what we're doing, because most of us really enjoy, and I think we do recognize we're privileged to do this type of work. And at times it also means not taking on too much, so you can actually really enjoy what you're doing. And I think, and I hope and I expect to see more change in this respect too, because lawyers have always worked hard, but the race to the bottom is counterproductive long term. So again, to go full circle and on was reference to what Aku told us earlier today, the half Fridays that Sorainen had implemented in summer. You know, there might be other things to do, but I think this one is a really good one.
So we are all off now, or? Are we all off now? It's half Friday today.
It's half Friday. Very good. With that, may you all have a good second half of the Friday.
Thank you. Thank you very much, Ginta. Thank you, everyone. And this webinar has been really both informative and inspirational. And I feel like I have to watch the recording once again. By the way, the recording will be available shortly on our website. And we have come to the end of this fantastic event. I ask the audience to please join me in thanking our excellent speakers. Thank you everyone for participating. Stay safe and see you soon in real life.